We're on the record in cause number 327100, and the case is styled the state of Texas versus Tiffany K. Quello. Ms. Quello, is that your full name?
Yes, sir.
Ms. Quello, would you please raise your right hand? Ms. Quello, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Ms. Quello, you may put your hand down. How are you doing, Ms. Quello?
Just fine. How are you?
That's good. Ms. Quello, I have before me an information that alleges that on or about June 4th of 2020, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of criminal mischief. Ms. Quello, do you understand what you've been charged with?
Yes, sir.
And to this charge, Ms. Quello, how do you plead? Guilty, not guilty, or no contest?
No contest, right?
Now,
No contest.
No contest.
are you pleading no contest freely and voluntarily?
Yes.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes.
Ms. Quello, I have before me a document that is titled Misdemeanor Plea Admonishments. It is also labeled as State's Exhibit Number 1. On page 2 of this document, there are a set of initials TC on a line that's next to a box that's checked nolo contingere, which means no contest.
Yes, sir.
Are these your initials?
Yes, sir.
And on page 3 of the same document, there's a signature at the top of this document. And hold on, Miss, you say your name is Tiffany K. Quello, is that correct?
Yes, it's been changed since like 10 years ago, but they have me under Quaylo.
She also goes by Tiffany Frege, Your Honor.
Yes,
Okay, because I see a Tiffany Frege, that
Yes,
is,
sir.
is that your signature?
Yes, sir.
Now, on the next document, which is a trial court certification of defendant's right of appeal, there's a signature at the bottom of this document above the line that says defendant. It says Tiffany Frege. And is that your signature?
Yes.
Now, at the top of this document, hold on, let me do this here. Let me do this. Okay, now, on these two documents, you're also known as Tiffany Frege, is that correct?
Yes, sir.
Okay, and I made a note at the top of the document that you're also known as Tiffany Frege, and I've initialed
Yes,
this
sir.
document. Now, at the top, now, on this document that is titled Trial Court Certification of Defendant's Right of Appeal, the one that you identified your signature as Tiffany Frege next to your attorney's signature, there are two boxes that's checked at the top of this document. The first box states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box states that you're waiving your right to appeal, which means you're giving up your right to appeal. Do you understand that?
Yes, sir.
Now, you should have signed, did you sign a document out there that is titled the discovery certification?
No. Oh, yes, I did. Sorry. Yes, sir.
Okay, now, prior to signing these documents, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to
Yes, sir.
your knowledge? Okay, now, Mr. Matuska,
Yes, sir.
do you have any objections to me, I guess, writing on the State's Exhibit Number 1 in the trial court certification that she's also known as Tiffany Frege?
No, Your Honor.
State, do you have any objections?
No objections.
State, do you have any
No,
objections?
Your Honor.
Okay. Okay. Now, Ms. Quello, prior to signing, and I'll actually did, prior to signing and issuing these documents, did your attorney go over these documents with you?
Yes, sir.
Did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, I have before me states exhibit number 1. State, you like to offer states 1?
Yes, Your Honor, and I'd also like to offer State's Exhibit number 2, that's the probable cause affidavit for this case.
Mr. Matuska, do you have any objections?
No objections, Your Honor.
No objections. States exhibits number 1 and 2 are admitted. Mr. Matuska, you've advised and counsel Ms. Quello. Is there any evidence that she is currently mentally incompetent to stand trial?
No, Your Honor.
Ms. Quello, your attorney, Mr. Matuska, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Ms. Quello, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea of no contest and waivers were freely and voluntarily given. State, do we have a plea bargain agreement?
Yes, Your Honor, it's for 30 days credit for time served, tax and retire of the court cost.
Okay, Ms. Quello, the state is offering that you serve 30 days in the Jefferson County Jail, but you will not have to serve any more time in the Jefferson County Jail in this case because you've already spent 30 days in jail. Therefore, you'll be given credit for time served. If you
Yes, sir.
pay any court costs, the court cost would be $387. However, you would not have to pay any court costs because the time that you spent in jail has already paid it off. Therefore, your court costs will be taxed and retired. Ms. Quello, do you understand the state's offer?
Yes. Yes,
And-
sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay, Ms. Quello, I'll follow the plea bargain agreement that you have entered into with the state. And Ms. Quello, this will conclude your case. Please follow the bailiff and you have a blessed day.
Okay, you too. Thank you so much.
Okay, you're welcome.
Okay.
Terrence. Up there.
Ryan,
Yes, sir.
the next person there, I think already signed up. Okay. That's
Mr. Trainer.
Okay.
Look like you broke some shit.
Yep.
We're on the record in cause number 328764. The case is styled the state of Texas versus Hong Tran. Mr. Tran, is that your full name?
Yes, sir.
Okay, Mr. Tran, would you please raise your right hand? Mr. Tran, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Okay, you may put your hand down. Mr. Tran, how are you doing?
I
Fine.
feel so
Okay,
so bad. But the law locked me up for no reason. I do time already, sir. But pick me up the second time, throw me in jail for more than 3 weeks.
Mr. Tran,
And
you have,
yes, sir.
okay, just
And
hold,
anyway, I in here, my tooth
Mr. Trent, just hold on a minute. I have to read something to you. Now, Mr. Trent, the information states that on or about December 28th of 2020, while you were in Jefferson County, Texas, that you committed to Class B, Mr. Offense of criminal trespass. Do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Tran, how do you plead? Guilty, not guilty, or no contest?
Guilty, sir.
Now, are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
All right, Mr. Tran. I have before me a document that is titled that is titled to misdemeanor plea admonishment. It is labeled as State's Exhibit Number 1. On this document, Mr. Tran, on page 2, there are a set of initials, and the initials are HMT. Did you place your initials on this document?
Yes, sir.
And on page 3 of this same document, there's a signature above the line that says defendant. Is that your signature?
Yes, sir.
And on the next document, which is the trial court certification of defendant's right of appeal, there's a signature at the bottom of this document above the line that says defendant. Is that your signature?
Yes, sir.
And there are 2 boxes that are checked at the top of this document. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
And the second box that's checked states that you are waiving your right to an appeal, which means that you're giving up your right to an appeal. Do you understand that?
Yes, sir.
Now, Mr. Tran, did you sign a document or document out there that is titled the discovery certification? It was a paper that your attorney gave you out there. Did you sign that? It says discovery certification.
Yes, sir.
Now, Mr. Tran, before you signed and initialed these documents, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Now, Mr. Tran, are you a U.S. citizen?
Yes, sir.
Okay, State, I have before me State's Exhibit Number 1. You like to offer States 1?
Yes, Your Honor.
Mr. Matuska, do you have any objections?
No objections, Your Honor.
Okay, no objections. State's Exhibit Number 1 will be admitted. Mr. Matuska, you have advised and counseled Mr. Tran. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Tran, your attorney has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Tran, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea of guilty and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor. It's for 23 days, credit for time served, tax, and retire of the court cost.
Mr. Tran, the state is offering that you serve 23 days in the Jefferson County Jail, but you will not have to serve any more time in the Jefferson County Jail because you've already served 23 days. Therefore, you will be given credit for time served. If you owe any court costs, the court cost is $327, but you will not have to pay that because the time that you spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. Mr. Tran, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay, Mr. Tran, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Tran, please follow the bailiff. This will conclude your case, and you have a blessed day.
Yes, sir.
Okay.
You done?
Yes, sir.
Barnes.
We're on the record in cause number 323876. The case is styled the state of Texas versus William Wayne Burns. Is that your full name?
Yes, sir.
Mr. Burns, would you please raise your right hand? Mr. Burns, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
I do.
Mr. Burns, you may put your hand down. How are you doing, Mr. Burns?
Good, how about you?
I'm doing fine. Thanks for asking. Mr. Burns, I have before me an information that alleges that on or about January 19 of 2019, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of theft of services. Mr. Burns, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Burns, how do you plead? Guilty, not guilty, or no contest?
Good.
Now, you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
Mr. Burns, I have before me a document that is titled the misdemeanor plea admonishment. It is also labeled as State's Exhibit Number 1. Okay, Mr. Matuska, looked like he just put one of his initials on the document. I'm gonna send it back to you.
Thank you, Judge. I had a problem with some letters disappearing earlier.
Oh, okay.
Not sure why. Sorry.
Oh, yeah, there's a, on the stylus,
Yes,
there's
sir.
a button. Don't push that button that's on the stylus because that can affect the signature, the mark. Yeah, that little, don't push that.
Always wondered what that was for.
Right. Yeah, that erases it or something.
Where they put the eraser where you draw?
No, you can turn it upside down, but for some reason I don't know if it has an effect on the signal or something.
Yes,
But
sir.
for some reason, yeah, just don't touch that.
I have it up now, sir.
Okay. Yeah, right.
Just the top. B. Thank you. It's in there, Judge.
Okay. Uh-oh, my thing's starting to act up now. Shoot. My tablet is starting to act up. Could I get another one?
You may have to it's telling you it's dead.
It's the whole screen and turned gray.
Oh, yeah, mine did too. I
Judge, did it go through?
It may have, I'm having some problems with my tablet.
Yeah,
too.
I think mine just froze.
got it, yeah.
Yeah,
The whole system's down.
yeah, I'm just trying to get it back up. Just hold on a minute.
Somehow we're still on YouTube though.
Yeah, I got it on YouTube. Trying to figure out how. It's still.
Judge, I just resent it.
Yeah, I'm still having problems with this tablet. Let me see. Hold on a minute.
There it is, it came through,
Yours, okay, yours came through.
yes,
Okay, yeah, we got it.
got it, okay.
Okay. Okay. Okay, now, we're back on the record in cause number 323-876, case of style of state of Texas versus William Wayne Barnes. We have Mr. Barnes here. Mr. Barnes previously earlier pled guilty to the offense of theft of services. And Mr. Barnes, I have before me a document that is titled misdemeanor plea admonishments, which is also labeled as State's Exhibit Number 1. On page 2 of this document, there are a set of initials on a line next to a box that says guilty. The initials are WB. Mr. Barnes, did you place your initials on this document?
Yes, sir.
And on the next page of the same document, there's a signature above the line that says defendant. And this signature purports to be your signature. Is that your signature?
Yes, sir.
And on the next document, which is titled Trial Court Certification of Defendant's Right of Appeal, oh, he didn't sign this one. Mr. Matuska, he didn't
Yes, sir.
sign.
Does that disappear too?
Yeah, it's gone. Yeah. Let me send it back. Uh,
Careful not to push that.
Just do not push it.
I got it, Judge.
Okay. Okay, we're back on the record in cause number 323876. Case of style state of Texas versus William Wayne Barnes. Mr. Barnes, when we went off record, I have before me a document that is titled Trial Court's Certification of Defendant's Right of Appeal. On this document, Mr. Barnes, there's a signature above the line that says defendant. Is that your signature?
Yes, sir.
And there are two boxes that's checked at the top of this document. The first box states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes.
The second box states that you're waiving your right to appeal, which means that you're giving up your right to an appeal. Do you understand that?
Yes, sir.
Now, Mr. Barnes, did you sign a document out there that is titled the discovery certification? It's on a sheet of paper, is document that's titled discovery certification.
Yes, sir.
Now, prior to,
I'm thinking I did. Oh, yeah.
It was the one you gave him.
The one I just sent, yes, sir, I did sign it. Did.
okay, now, Mr. Barnes, prior to signing and initialing these documents, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State I have before me states exhibit number 1. State you like to offer states 1.
Yes, Your Honor.
Any objections, Mr. Matuska?
No, Your Honor.
No objection, states exhibit number 1 will be admitted. Mr. Matuska, you've advised and counsel Mr. Burns. Is there any evidence that he's currently mentally incompetent to stand trial?
No, sir, Your Honor.
Mr. Burns, your attorney, Mr. Matuska, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Burns, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea of guilty and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor. It's for 45 days county jail.
Mr. Burns, the state is offering that you serve 45 days in the Jefferson County Jail. You will also be required to pay court costs of $447. Mr. Burns, would you be able to pay the $447?
No, sir.
I can't hear you.
Not here. Sir,
What did you say?
not at the time being, I won't.
Okay, so you're not able to pay the $447. I need to ask you some questions, Mr. Burns.
Yes.
Mr. Burns, are you employed?
No, sir, I'm not.
And are you married, single, divorced, separated, widowed?
Separated.
Separated? Okay. Now, do your spouse have a take-home pay?
I have no spouse. Single.
Oh, so you're single?
I'm saying, sorry.
Okay. Now, are you receiving any child support?
No, I actually pay child support.
Okay, do you receive Medicaid,
No,
SSI,
no,
SNAP,
no,
TANF?
no,
Do you live in public housing?
no,
Do you receive any type of governmental checks?
no,
Do you have any other form of income?
no, sir.
Do you have any assets? Do you own a car or a home?
Currently, no.
No. And do you have, do you reside, or do you pay rent?
No,
Okay, do you reside with a family member?
no.
Are you homeless?
I actually have a home that I just received recently, but it was inherited. And,
Okay, so it's a home that you own. Okay. Okay, well, so that's an asset. You have any idea what the value of it is?
it's actually not an asset due to the fact it's inherited and shared between brother, sister.
Oh, so you just
all
have it,
three.
so you have an interest in the home.
Not legally yet. Legally, it's still in, grandmother's name that has passed away, so legally, it's not necessarily.
Okay, so
an
you don't,
asset yet.
okay, okay. So, okay, it's,
So I really have nothing, and right now, at this time, I'm not necessarily homeless, but, I do have a place to go.
okay, are you paying rent at that place?
No, no,
Are you paying the utility, water, the gas bills?
nothing.
And, do you have any children?
Yes, sir, I do.
Are you ordered to pay child support?
I am.
How much are you ordered to pay each month?
It's around 400 a month.
Okay, now, food expenses. Is somebody else paying for the food, or are you paying these food expenses?
Uh, when available, somebody else, yes, sir,
Okay,
and myself whenever I can.
okay. Now, transportation costs. You have to pay for transportation?
No, sir, I don't.
Okay, you have a cell phone?
I do have to pay cell phone whenever like I say,
How much is
and that's usually, 65 a month,
65?
if able.
Okay. And are you paying any probation fees?
Uh, no, sir, I'm not.
Okay, do you have any medical expenses
No, sir,
and any credit cards that you ordered to pay?
no, sir.
Okay, the court is gonna find that you're indigent. And pursuant to Article 42.15 of Texas Code of Criminal Procedure, your court costs are going to be waived. All right, so what I mean by that $447 court cost is going to be waived.
Yes, sir.
Now, let me repeat the offer. The state is offering that you serve 45 days in Jefferson County Jail. You'll be given credit for any time that you're entitled to get by law. The court cost of $447 will be waived because the court find that you're indigent. Mr. Burns, do you understand the state's offer?
Yes, sir, I do.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes,
Okay, Mr. Burns, I'll follow the plea bargain agreement that you've entered into with the state. Mr. Burns, this will conclude your case. Please follow the bailiff and you have a blessed day.
yes, sir.
Your Honor, that was
Yes,
the last case of Mr. Matuskas that I think that we have worked out an agreement on. I didn't know how you wanted to handle all the cases that we were going to be asking for resets, and if you were wanting to bring the defendants in. I know they're having some issues with that.
I think Mr. Matuska is gonna ask for resets on them. I don't know if we need to just necessarily bring them in. We just have to get resets dates from our court coordinator for
Yes.
Mr.
Judge, they had some problems. There was some overcrowding issues, so I was trying to help them with that.
Well, I mean, I'm not doing it because of that. The issue is you saying that you want resets on the other cases. My thing is you don't need to have them brought up if you just asking for resets.
Would you
Yes, sir.
like me to go down the
We have a
docket?
competency issue on
Well, what we
DeStefano,
can do
Judge.
is, let me do this here. Let me get the court coordinator. And we'll go down the docket and the court coordinator give you some dates. Okay. Okay. Let's see, who do we have? Let's see. Okay, you gonna put them all on the same day? You want them, Mr. Matuska, you want them all on the same day? Or you just,
Whenever, Judge, I was hoping Ms. Jones maybe next week.
okay, whatever. Okay, let's do this here. Let's put him. Okay, we're gonna go down the list. The first case we have is Shannon Richard. Shannon Richard have 3 cases, cause number 3222288, cause number 3270080, cause number 328354. And give us a date on that. Yeah. Okay, that case is gonna be reset to April 29th of 2021. Mr. Matuska, we will send you your reset.
Yes, sir.
All right, now the other thing is, let's see, the next case. Let's-
Jacinda Jones.
Jones, yeah, Jacinda Jones, cause number 326670. Will give us a date on that.
I think Mr. Matuska was hoping to have that one set next week.
Okay, that's the date, that was the date we given them, huh? That's the same one we given them, all of them gonna be on the same day, April 29th.
So,
Okay, that one is April 29th as well.
okay, so we're just re-saying all of these just one week and then gonna do our jail docket for next weekend?
Hold on, let me ask Mr. Matuska, how much time do you need to get offers?
Well, Judge, Ms. Jones, she was the only one I think I needed within a week. The others aren't as urgent.
Oh. Well, we got Richard set on that next week as well. Okay, give us a date. Okay, the next one is, who do we have? Is it, no. Is it Matthews? Cedric Matthews?
Your Honor, Mr. Matthews bonded out.
Okay, he bonded out 18, okay. The next one is page 5. The next one is DeStefano, Jesse DeStefano.
Okay. Just definitely.
Yeah,
Bring him up, Judge.
okay, and then after that you have Jacob Murphy.
Still waiting on them to bring him up. They sent the wrong one first, but I do have DeStefano ready, or he's here.
Okay, you could bring in DeStefano. Okay. Hold on a minute. Let me do this.
Morning, Mr. DeStefano. Morning. Morning.
We on the record in two cases. First case is cause number 329-056. The second case is cause number 329-116. All two cases are styled the state of Texas versus Jesse Daniel DeStefano. We have Mr. DeStefano who is present with his attorney, Mr. Ryan Matuska. And we have the state present with the state assistance attorney, Mrs. Ashley Ramos. And let me ask a question to Mr. Matuska. Mr. Matuska, did you get a copy of the,
Yes, sir. Ms. Taylor's report?
of the report?
Yes, sir.
And Mrs. Ramos, did you get a copy of that report?
Yes, Your Honor.
Okay, now, and that report is pursuant to Article 1622 of the Texas Code of Criminal Procedure. I just had it. And now pursuant to Article Point 24 of the Texas Code of Criminal Procedure, the proceedings and trials in all courts shall be public. However, pursuant to Lilly versus State 365 Southwest 3rd 321, the right to a public trial is not absolute and may be outweighed by other competing rights of interest, such as interest in security, preventing disclosure of non-public information, or ensuring that a defendant receives a fair trial. Now, Mr. Matuska, pursuant to Lilly versus State, are you requesting that this hearing be closed to the public because of the possibility, to prevent disclosure of non-public information?
Yes, sir, Your Honor.
Okay, say you have any objections?
No, Your Honor.
Okay, so at this time, the court will find that the parties seeking to close the hearing have advanced an overriding interest that is likely to be prejudiced toward the defendant. The closure is not broader than necessary to protect those interests. And the trial court finds that there are no reasonable alternatives to closing. The trial court has considered reasonable alternatives to closing the proceeding, and the court makes a finding that adequately supports the closure. So at this time, this hearing pursuant to Lilly versus State 365 Southwest 3rd 322 will be closed to the public.